So I'm the CEO of MedBrief, and I'm here with Sean Linley. So Sean, we met at AVMA. We were sat together at the evening dinner, and we spent a couple of hours geeking out about technology and about costs. And it was very enjoyable. So I really wanted to set this up and have a sort of a deeper dive, I guess, on cost, all things costs, and particular some of the sort of recent highlights in terms of the cost world. But I wanted to start out by, I did speak to a couple of your colleagues. I know you're originally from Leeds, and a proud Leeds United fan. So for your troubles. So Sean, what tore you away from a glittering career at Elland Road to being a cost lawyer?
Well, first and foremost, when I was probably at a prime age for that glittering career, I had to say that Leeds United were not quite so glittery. They were somewhere down in League One back then, and went to some pretty horrendous results. But for me, I think my cost career did start out in Leeds. When I finished university, and I think anyone who does cost will always tell you the same thing, which is that it's not a career you seek out, generally speaking, and it was something that I fell into. So I had a friend who was working in costs at the time. I just finished university, and I was thinking, well, I need to find a job. And she told me, for whether it was for the best or for the worst, she said to me, oh, we've got jobs going here. And that's basically where it started. It was sending in an application, going in and doing the interview, as not knowing anything about the job, anything about the role. And then it sort of just stuck from that. And I've been very blessed to have a lot of opportunities in different aspects of the cost world in the years that have gone since.
Yeah, I had a very similar experience of kind of falling into a career as a solicitor, very much by mistake. I guess, Sean, I'm trying to think of where we left off at dinner, and it probably makes sense to start with fixed recoverable costs. The topic has been dealt with exhaustively. I was having a look at some of the podcasts. There's a very accessible and insightful treatment of it in Gillian Gadsby's podcast. There's lots of material on Carter Burnett's own website, and I saw a really good article on Kennedy. So there's just a huge amount of material on the topic, and yet it remains top of mind, I think, for all of the solicitors in our industry. And I was thinking about why it's so pervasive, apart from the obvious reasons of everyone wants to get paid. I think it's more fundamental than that. You know, it goes right to the core of access to justice and this tension that exists between the very understandable desire of the NHS resolution to, try and robustly scrutinize the claims, and also introduce some kind of control onto the spiraling costs. And then, on the other side, the desire that everyone in the industry has to make some kind of effort to get at the merits of the legal case and investigate those properly, and that obviously costs money. So how do you think about whether fixed recoverable costs is threading the needle of those two items that are really in tension, and what are the actual practical real world effects of fixed recoverable costs in 2025?
Yeah, it's an interesting question, because depending on who you ask, I think, as you kind of hinted at there, you get two very different interpretations and two very different answers. I think one of the things, so Sir Rupert Jackson, if we sort of strip back as a bit of a history lesson, much of the fixed cost reforms we see today, if you trace back and you can read his old reports, and if you read those old reports, you'll see it translated into the actual implementation that we have. And one of the things, and I think the head of this is that Sir Rupert Jackson's intention was to reduce legal costs. He saw legal costs as a barrier to access to justice. And it was about ensuring that there was a way that you could have affordable access to justice, but also trying to reflect the fact that there is a cost to litigation. It's like anything, there is a base cost. And if you start saying to someone, well, it's got to be less than that base cost, suddenly the providers will just disappear. And I think that's the fine line which you're trying to balance. And Sir Rupert Jackson himself said, and this was when he was talking back in 2017, excuse me, where he said, if the costs are too high, people cannot afford lawyers. If the costs are too low, there will not be any lawyers doing the work. And I think where we are at the moment is we're still, I hesitate to say we're in a bedding in period, because anyone out there who's listening who does low value, or what would be classed as low value PI work, that's PI work that's a value of less than 25,000, will tell you fixed costs has been around for well over a decade now. Whereas for everyone else, that extension of most claims up to 100,000 is really only just being felt. So even though that came in October 2023, from a judicial perspective, they've not actually dealt with this that much. A lot of firms which I deal with haven't dealt with the new regime that much yet. And I think a lot of that boils down to the transitional provisions and the way it just takes time for cases to kind of work their way through. But I think the real underlying issue is that fixed recoverable costs are exactly that. They fix the costs between the parties. They don't fix the costs between a solicitor and a client. So from an access to justice point, when you're thinking about equality of arms in terms of the actual litigation itself, someone who has greater financial capacity, it can effectively spend whatever they want on the litigation. And then I think the other kind of unsettling point under it all, which a lot of people would reflect on as well, is the deterrent effect of costs. And it remains to be seen, I think, at this stage. I think it's too early to say for certain whether or not will we see more cases proceeding to trial on the basis of fixed costs. Will we see more cases resolve earlier? I don't know what the exact answer to that is going to be at this stage, but I think that's going to be a really interesting thing to watch, because judicial time is very precious, as we know. And if you do start to see more judicial time being used because more cases are proceeding to trial, because there's more of an appetite to fight cases on the basis that, you know, a firm may look at it and go, well, this case is going to cost me X, Y, or Z, as opposed to, oh, actually it's going to cost me a lot more. So that's, I think, another interesting kind of point to look at. And I think in the early cases since the October reforms as well, we've had a lot of inconsistency in the judicial approach, which obviously, I think whenever you have new reforms, there's always a degree of uncertainty. And that's beneficial to parties as well, because you can make use of that. That's where you can start prodding and poking at the rules and the interpretations. But equally, obviously, that gives rise to a lot of satellite litigation. And I think a lot of the, particularly the early instructions that I've had on the post-October front, I think there hasn't actually surprisingly been that much of an appetite to push some of these cases on. I think there's been a kind of an acceptance of almost meeting a middle ground. So that's my experience. And I think for a lot of, in terms of your question, going back to sort of balancing the cost of litigation, I think for a lot of non-PI firms, where you tend to see those cases run on a private retainer, the feedback that I've always had on that is, well, the litigation costs what it costs. And the only thing that's actually altered is what the client can get back. As I think where you've got CFA cases, you know, the no-win, no-fee agreements, I think that's going to be where it's a lot more interesting. And I know anecdotally that the regional cost judge in Newcastle has mentioned that she has seen an uptake in solicitor on client assessments, which I think is quite telling, whereas the actual between the parties assessments have decreased. So I think that's really quite interesting.
I think that is a concern that I've heard. Well, certainly the satellite litigation, obviously, and there's some solicitor-client litigation. It's going to be difficult to resolve. And I guess it leads us on to the next question, really, with the next obvious logical question, which is, you know, is there going to be some kind of rise in in costs lawfare, I guess. Like in my previous life as a commercial solicitor or in commercial litigation, procedural applications and cost lawfare were just part of, everyday litigation. You very often had two very well-funded or litigation-funded sometimes parties, and that was just part of doing business. And it's been my experience since I had exposure to clinical negligence that the parties are much more collaborative, perhaps not as much as they would like to be, but certainly in comparison to some of the other areas of law, they both parties are very genuinely concerned to get to a fair outcome. And do you have any concerns about this, fixed recoverable costs starting to kind of derange the incentives of the way that litigation is conducted?
Well, I think the first thing, just to track back a little bit there, is that obviously we've seen through things like Churchill and Merthyr Tydfil, and even in terms of the overriding objective, is we see these introduction of mandatory ADR in small claims cases, which I think is, and also the fact that the court can order parties to engage in ADR, which I think shows a real tonal shift. Because even if you want to get into kind of a lawfare kind of attitude, as you put it, I think there is an encouragement from a judicial level to look at alternative dispute resolution, things like mediation. And like I say, embedding that within the overriding objective, I think shows how important that is. The other thing as well is from a fixed recoverable costs point of view, and I think this is kind of interesting as well in terms of where ADR sits in the whole kind of scheme of things. So on the intermediate track, you can recover the costs of ADR. So if you have a mediation, it's fixed depending on the complexity of the case. But on fast track, there is no defined fixed recoverable cost for that. So obviously a small claims track, generally speaking, you don't have recoverable costs. So it's kind of interesting to see how ADR fits into a fixed cost scheme where there is no recoverable cost of doing it, because I don't know what the incentive is to a party, because I can imagine a lay client who's perhaps privately funding a claim saying, well, why would I pay for that when you're telling me I can't recover it? So there's definitely a tension there between the courts encouraging this uptake of ADR, but also not allowing a recoverable part of it in terms of costs. And I think if you factor it out on a kind of a bigger level, I guess it comes back down to the point that I was sort of hedging towards before, which is the fixed costs as a deterrent effect. So when you're talking about sort of lawfare, there's that question mark, and I think it'll be more borne out in years to come when we look back at the statistics. But will we see firms more willing to fight cases? Will firms be more willing to sort of take on some of these satellite litigation points? So particularly from a costs perspective, under the fixed cost recoverable cost scheme, or at least the post-October rules, the costs of the dispute are fixed in terms of the costs. So if you have a cost dispute in terms of a fixed recoverable cost case, they're fixed at a maximum of £500 plus VAT. And I can see a cogent argument from a receiving party perspective and a paying party perspective to say, for £500 plus VAT, at most, it could actually be less, depending on when. It's complicated, but it depends on when the actual dispute's resolved. But, £500 plus VAT, you might be thinking, well, actually, it's worth a go, because this might affect a number of cases. And certainly what I'm seeing just from my own personal workload, the inquiries that I'm getting and the number of fixed cost disputes that are coming in has definitely increased, and the appetite to push those has certainly increased as well. Whereas I think when you get cases which aren't fixed from a cost perspective, sometimes there's a bit more, there's a larger economic sort of mindset, I think, where people think, well, actually, are we going to risk X to get Y? Whereas with fixed costs, it tends to be either or. I think costs will always be a law for people are always going to try and get advantages out of that. Within the fixed cost scheme itself, it's got embedded in it an unreasonable conduct sanction. So if the receiving party acts unreasonably, they'll lose 50% of their fixed recoverable costs. Whereas if the paying party acts unreasonably, they have to pay an extra 50%. So there's things embedded in the rules, I think, to try and encourage parties to work together. And I think ADR is probably going to be the thing where we'll see the biggest rise. And I wonder, with that in mind, whether that might actually see lawfare potentially reduce, or certainly from a judicial perspective. I think that's what they'll be hoping, and then coupling that with sanctions in relation to costs, I think we'll be, effectively be trying to push people away from that kind of approach. But I think it'll always exist, because in my time in costs, it always has.
Yeah, I'm sure. Just a side note, the intermediate track cases, how many of those are you seeing?
So at the moment, the intermediate track cases that I've had, bar, I'd say maybe 2 or 3, have all been non-PI cases. So the way the transitional provisions work is that if a claim includes personal injury, effectively, if the accident date predates the 1st of October 2023, it proceeds under the old rules. So a lot of the PI cases I get are either under the old fixed cost rules, because the cases which were commenced before the new rules came in, or where they have come in, like I said, these 2 or 3 cases, there have been cases which have settled very, very quickly. And actually, I've had 2 cases where the fixed costs have been higher than the time costs on those particular cases, because they resolve so quickly. I'm not suggesting that's going to happen with regularity, but on the ones which I've had, a lot of them are set up pre-allocation and pre-assignment. So that has then bled into arguments around, well, actually, is this an intermediate track case? Is it a fast track case? Is it a multi-track case? Obviously, multi-track would not be fixed costs. And then beyond that, then you start getting into the realms of, well, actually, in terms of assignment, what complexity band it is. Because on the scale of complexity band, obviously, the higher the complexity band is, so it's 1 through 4 for both fast track and intermediate track. But the higher that complexity band is, the higher the recoverable costs are. So there's obviously a desire, wherever possible, to say that your case is the most complicated case. It fits in the highest band. In reality, it's not that straightforward, but that's what you're kind of trying to do. But I would highlight this as sort of a point of note, and say a procedural point actually, which is that CPR 45.13b and the Court of Appeal decision in a case called Doyle basically permit parties to expressly contract out of fixed costs. And that is particularly interesting because I've had a number of cases come through to me which would be prima facie fixed costs, but the parties have agreed settlement terms which actually permits them to recover costs outside of fixed costs, different kinds of litigation. You're going to have some law firms who have big teams where, for example, work can be delegated to a more junior level. There's certainly a lot of the lower end fixed cost cases. When you look at the numbers that are involved, if they're going to remain profitable, something's got to kind of give somewhere, and it's not going to be your grade A fee earners working on those lower value cases. But I think there has to also be a recognition that there are firms who don't have the resources to necessarily delegate that work. They don't necessarily have the resources to invest in technology, whether that's case management systems that can maybe generate some of the procedural steps, some of the letters and correspondence, that kind of thing, that give you kind of the basic templates. So it's trying to weigh up what works for one and what works for another. And I think when you were picking up before about the NHSR's comments around legal costs, well, actually, I think the other thing to bear in mind is that when you look at the NHS reports, the biggest part of the expenditure is and always has been damages. And I think there is also that fair question, particularly if it just stopping on clinical negligence for a second, which is that the real way to drive down costs is to just stop the negligence, which I know is easier said than done, and I'm not putting that out there, but I think the real sort of telling whenever you look at any kind of cost reforms is not so much is it reducing costs, particularly in a clinical negligence setting, but is it actually reducing the instances of the negligence? Because I think the real concern is that you just get people who just don't bring claims because suddenly they can't afford that representation, or that representation is just not there. I've certainly spoken with firms in terms of the low-value PI, so looking at really like sort of low-value RTA claims, where they have made effective board-level decisions to no longer represent people in those cases unless they can pay privately because they can't make it pay. And that doesn't mean those accidents aren't happening. It doesn't mean people aren't getting injured. It just means that the access to representation was gone. And that is always going to be the kind of the real sort of clear, I think, tension in these. But when you start to look at your question about suppliers and how can they kind of collaborate with that, then, and I think it's worth as well just stopping the fact that when we talk about proportionality, there's sort of two aspects to that. So you picked up on the point about it being what's the lowest possible spend. But actually, we've kind of moved on in terms of the judiciary sort of guidance since then, which is that reasonable and proportionate cost sits within a range. So it's not necessarily the lowest value, it's what is within a reasonable and proportionate range. And that is discretionary, so it's really difficult. It's going to be different for every case. And that's kind of what fixed costs is meant to circumvent, which is that you just have this one size fits all for whatever particular case it is. And so Rupert Jackson was always clear that for it to work, there would have to be procedure in place, which is why there's certain cases which don't fit within fixed cost criteria. There are exemptions which we have under Part 26. And actually you sort of almost see with clinical negligence, it's sort of a strange nebulous in that certain clinical negligence cases currently fit within it. That's those where breach of duty and causation are admitted and they're on the intermediate track. We've currently got a complete desert for the fast track cases. We've got no idea what's going to happen with those yet. That's still, at the time of recording, I should say, unknown. By the time this comes out, who knows? Maybe things will have moved on. So you're trying to kind of weigh up how do you plan for something which there's still a lot of uncertainty around. For suppliers, I think, who may be claimed as, particularly those who are claimed as a disbursement, generally speaking, disbursements are not fixed, even within a fixed cost setting, which makes them particularly interesting. And they also tend to be the areas most in dispute. Because once you address what track a case is and once you address what complexity band a case is, there isn't really that much left to argue about in terms of the solicitor costs, because you kind of then just follow the natural flow of the tables, and you might have little wiggle rooms around, well, did you use this bolt-on like ADR, and who's a specialist legal representative in the context of some of the other bolt-ons. But broadly speaking, that's done. But with disbursements, that's where it kind of gets interesting. That's where the pressure then ramps up on firms, because what you have now is a scenario where the solicitor costs are being compressed down, because the whole point of fixed costs was always to reduce costs. So there's no getting around that. That's what it's there to do. That's why it's here. But then if you get a situation where you're judging the proportionality and reasonableness of disbursements against the recoverable costs of the solicitor, well, if those recoverable costs of the solicitor have come down, then there's a natural inclination, I think, from a judicial perspective to say, well, this £1,000 report, this kind of no longer looks reasonable and proportionate, because then you start to hear things like, oh, that's 10% of the cost of the claim. For just as an example. So you start to see it in kind of expressed in that kind of different way, which is that holistic view to stand back and go, how does this compare to the rest? Now, obviously, the difficulty for law firms with a lot of these suppliers is that the fees are the fees. It's what they have to pay out. But then the question becomes is, if the judge, for example, says, and we had a case called, it's a case where it was in the county court in London called Santiago, and this was all around interpreter fees. And in fact, what the judge did was he was looking at the quantum of the interpreter fees, and the claimant in question had provided a range of fee estimates. And this range basically showed that the fee which had been claimed sat roughly in the middle, maybe just a little bit above the middle. And that's where we come back to that in the ocean of reasonable and proportionate range. But what the judge did at the end was said, well, yeah, you've got this comparable evidence. It does sit between them, but I still think it's a bit too high. So, excuse me. So even in a case where you have the comparable evidence, which shows that this figure sits within what has been charged within the wider marketplace, you've still got a judge who sits there and goes, I'm going to knock this down. And then say it gets knocked down and then you lose £200. The question then becomes, who's actually paying for that? Because the supplier will want that fee, and the client, does the client pay for it? Does the solicitor pay for it? Because if the solicitor's paying for it, they're already seeing their costs eroded. And I think that's where the real difficulty is. It's these shortfalls, which is where do these suddenly go? And it gets really tricky with clients because, you've got this is where you get into the whole, have you had informed consent? Was that fee unreasonable to begin with? It gets quite tricky.
It's very tricky. I mean, This precise point was dealt with on Gillian Gadsby's podcast, because they were saying, well, if eventually, those costs erode, they're going to erode the end client's claim. That will naturally happen because there'll be a threshold below which solicitors just won't be able to run a case. But I spoke at AVMA, I think it was, to a solicitor who had taken a hit on and covered the costs of, I think, about 30% of an expert's report, just because the court wouldn't. It was, I think it was about a £15,000 report. It was a very, very complex case. And the other problem that's become apparent to me as I've become more familiar with the industry is that actually the quantum doesn't necessarily have a very clear relationship with the costs of the case or the complexity of the case. And so that makes it very, very difficult. You may have a claim that's only worth sort of £10,000, but it requires, 3 or 4 very experienced experts. And in this, in this particular field, the expert reports are really critical. And it's a good segue into the other thing that we need to talk about, which is the MRO, the medical report organization. What that I think is a real crisis in the industry at the moment. What is going to happen since the Archibald decision? What's going to happen with the sort of tension between just a single opaque invoice and the decision or what the judge had to say in that case? What is your thinking? I mean, have you looked into your crystal ball and thought about what's going to happen in the future with how MROs manage that conundrum? Because I think it's a really difficult one.
I think you're right, Adam. I think it's a real difficult one, and I would say that on a day-to-day basis, just in terms of my sort of working pattern at the moment, it's one of the issues which I'm probably dealing with most regularly, and it is really tricky for a number of reasons. And I think before we can delve into it in a sort of bigger way, I think it's worth just pausing on the fact and saying that against the backdrop of all the arguments that we have, the medical agency element is recoverable in principle. Nobody is arguing that it is irrecoverable in principle. Lots of people will tell you this is an argument about transparency, around the transparency of fees and the charges which are being levied by the agencies. But nobody is saying that it's not right that the agencies do that work, and it's not right that it's recoverable in some form or fashion. You mentioned the JXX versus Archibald decision, which is kind of I'd say it's the latest big decision we've had in terms of the MRO points, but we have had sort of smaller unreported decisions since as well. And I think where we are at the moment is that we continue in a really kind of uncertain picture. So the two main central focuses are the decision in Hoskins still, and then you've got the decision in JXX. Hoskins, effectively, the decision came that there was non-compliance with the practice direction when serving a bill of costs, because within practice direction 47, one of the requirements when you serve a bill of costs is that you have to serve the expert fee notes. And the question in Hoskins then came to, is the composite fee note, that's the fee note supplied by the medical agency, is that the expert fee note? In that particular case, the court found that it wasn't, and essentially the rest is sort of history in terms of what happened. The agency in that case was ordered to provide the expert fee notes, and then that was kind of how that was left. That same week there was a different decision in a case called Sefton, where the judgment sort of came out quite thick and fast back then, and that basically found the contrary view, that you can sort of assess the expert fee and the reasonableness of it without needing to see the original expert fee. JXX is interesting because JXX doesn't specifically say that you need to provide the expert fee notes or even a breakdown. But what it does say that is if you elect not to provide a breakdown or the expert fee notes, then the fee will effectively be assessed as though there was no medical agency involvement. So JXX doesn't necessarily solve the tension, because what tends to happen is, and quite naturally, if an agency's been involved, then in theory, that expert fee might be a bit higher than if the expert had been instructed directly, understandably. So in effect, if you've got judges who are, in essence saying, we're going to assess this fee on the basis that there's no agency involvement, that's when you then start getting into these really kind of difficult quantum questions, which is that fee, if we pretend that an agency was never involved, does that look reasonable and proportionate? Or if it doesn't, again, we're then getting into this point of shortfall. And then that is where you then start to pick up these tensions between law firms and the agencies, because what you find across the industry is that you have some agencies who are more transparent than others. And quite often law firms will have agreements with agencies whereby they're just not entitled to get that information from the agency. So you kind of at the behest of whether or not the agency wants to provide that disclosure. And because you've got this conflicting, there's no binding authority at the time of recording. And because you've got no binding authority right now, the agencies are quite right when they say, well, strictly speaking, we don't have to provide this. And that's true. But equally, you've got judges who are using their discretion because there's no binding authority. They can come to whatever decision they feel is the right one. Some judges will want to see that information. They will want to see a breakdown. They will want to see the expert fee notes. Some other judges will sit there and say, well, no, actually, I can comfortably do this. And then it gets more complicated still, because within a fixed cost setting, that's not an assessment. So that's dealt with, again, quite differently. So with fixed cost cases, perversely, actually, you're less likely to need a breakdown. It's not to say that you would, because you might, but it's less likely. And the reason for that is because fixed costs, it's a summary exercise. It's not a detailed exercise. And what we've seen is quite a few judges within the fixed cost setting basically saying, well, actually, it's not reasonable and proportionate to expect a solicitor to go off and find this information, permitted that the expert fees in question look reasonable and proportionate. And that's key. But it is important to make that distinction, because the other distinction with fixed costs, and it tends to be the other kind of unknown element, which has sort of gone quite quiet actually, is that there is also an argument that if the agency element is meant to reflect work that the solicitor would have done, is that already covered by the fixed costs side of things? And at the moment, that argument seems to be very quiet. It doesn't really seem to be holding much fire. Certainly, there seems to be a tacit acceptance that some kind of agency element is recoverable, generally speaking, in fixed cost cases. But is there prospectively, does that resurface at some point? I don't know. But it's still there in the background. So you could potentially have a scenario in fixed costs where actually it's more favourable than detailed assessment, or you could have a scenario in fixed costs where potentially you start seeing judges returning back to this. It was a case called Powell's. Perhaps they adopt the Powell's approach of saying, actually, no, this is already recovered within your fixed costs. So, and there's a real tension, because you've got to remember that a large kind of attraction of using the medical agencies, it alleviates financial pressures for law firms, because you're in a situation where if the client can't afford to pay the medical fees, and some of these report fees, as you've pointed out, some of these report fees are significant, and most ordinary people, even if you said to them, can I have £1,000 to get a psychologist's report? Most ordinary people are going to say, well, no, I haven't been working for the last 6 months. I'm not getting paid. I haven't got any money. And then the law firm looks at it and goes, well, this case might not settle for 3 or 4 years. If we pay this out today, we're not going to get this back for 3 or 4 years. If they're doing that on every case, that suddenly builds up. You've got this massive lockup. So you then start to look at, well, what are the alternative funding solutions? And one of those solutions is medical agencies, because they can offer these deferred payment terms, which obviously effectively the hope is by the time the case resolves, those payment terms are still in effect. You settle the costs, that gets paid. But of course, you've got this issue at the moment, which I think is the other thing in the background here, which is less spoken about, which is if we do see more judges siding with that view of, potentially you need to provide the expert fee notes or a breakdown, and then you're not able to get that information. Again, you could end up in a situation where you've got shortfall, or even if, for example, those breakdowns show that actually the agency element is higher than maybe you expected, or the judge says it's just not reasonable and proportionate and they reduce it. You're then in a situation again where you're picking up these shortfalls, which is the difference between what's recovered and what's paid out. And the difficulty with trying to then recover that from a client is you'd be going back to the client and start saying, well, we've not covered this $3,000 report fee because they said the agency fee was too high or the fee overall was reasonable or disproportionate. But how can a client understand that, and how can the solicitor understand that if they don't know the makeup of that fee at the point at which it's agreed? So that's a real difficult tension. But I know as well that there are law firms who are looking at lots of different innovative ways. There are different funding products that are appearing on the market. But I think you're right to say that there is a clear need to get some kind of binding decision or agreement on this. What we know, I was at the Civil Procedure Rules Committee meeting in May, and what they said there was that there are cross-industry discussions ongoing with the hope of actually coming to some kind of agreement on this issue. So I think there is a recognition within the industry that this needs to be resolved, because it's not satisfactory, I don't think, for anyone. But I think the big future question mark is if it becomes the norm to provide breakdowns, and if off the back of that you start to see judicial decisions where judges are using their discretion and reducing those fees prospectively, will that decompress the market in the sense of it could be quite difficult for some agents because they may have to make decisions about, and for solicitor firms as well, because they'll have to make decisions about the value of what the agency is doing. Because for some firms, they'll look at it and go, actually, the value of the deferred payment and the service that I'm getting is so marvellous that actually it's worth any shortfall. And it's the same like when people pick experts. Some people will instinctively go for an expensive expert because they know that expert makes a difference to the case. So you might have that scenario, but equally you might have a scenario where you actually start getting law firms going to these agents saying, I'm never recovering the full fee here. I need you to, share a bit of this pain with me. And at that point, this is where the supplier decision has to come in, which is because they will have a level where they'll do their own numbers. They'll look at this and go, we know what we have to charge to be profitable. And if they can't charge what they need to charge to be profitable, then maybe that service falls away. And then you get into the realms of how does that impact access to justice in a more broader way? I mean, we're talking in hypotheticals, of course, but you can kind of see the different pathways where things can go. But in the meantime, in the here and now, whilst you've got this uncertainty, the arguments are pervasive. And all that's going to keep happening is you're going to get receiving parties who are going to say, we don't need to give this information. You're going to get paying parties who say you need to give it. And then what's happening is you get into the judge who's then basically making a decision based on what they think should happen in this particular case, as opposed to an overarching authority or guidance.
That was going to be my next question, which is how are the judges making that decision? In other words, are they, how are they establishing what is reasonable? Are they comparing fee notes of similarly experienced experts? Are they looking for fee notes to be provided from previous reports from the same expert? How are they undertaking that consideration?
So it can be done in a number of ways. For some judges, they'll feel that they've got the experience enough from other cases they've dealt with, where they can start to go, if you think about kind of your typical experts like a GP, an orthopedic, a psychologist, the experts that come up quite routinely, most judges will have seen those fees from other firms on other cases. And for a lot of judges, they'll feel confident enough and comfortable enough to be able to go, I know roughly as a benchmark what I expect these figures to be. They might have different ideas of what they expect that figure to be, but they'll have a broad idea. From in terms of like the parties actually having their arguments, there's things you can do. So you can look at getting comparative fees. You might have comparative fees from other experts. I, for example, have picked up sort of terms and conditions and fees from similar experts and sort of use that as my evidence to say, well, look, you're saying this expert fee is disproportionate. But if I look at this expert, this is what this expert charges, this is the hourly rate this expert charges. And then all of a sudden you can start to try and build a picture that persuades the judge that, look, this has to sit within that reasonable and proportionate range that we spoke about before. And of course the judge as well will take account the actual report itself or the actual work that's been undertaken, because that's the other thing. They're going to pick up the report. And this is always, I think, really important as as a file handler, particularly from a cost perspective. Because for some judges, they might pick the report up and go, you've charged $2,000 for a 3-page report. And then you've got to try and then somehow steer that in terms of, well, actually, what's the work that's behind that report? Because some of that might be the expertise of the expert. It might be a very niche kind of specialism. There might be a reason that a particular expert needs to be instructed. So like quite often in clinical negligence, you can't instruct an expert within the locale because they might be conflicted. So you have to go a bit further afield. How's that expert needed to attend in person? Are the particular, looking at things like the number of records that maybe had to be considered. And sometimes you go through that whole process and you stand back and you look and go, sometimes it is just high. There are some experts who do have a higher charge. That's it's up to them. We said before, disbursements generally aren't fixed. Experts' fees generally aren't fixed. So, you are going to get experts who charge what they want, but in theory, the market will just follow that because either the expert's so good that, like I say, they make a difference to the case and it's worth getting, or you're going to just get people will find alternative experts. I think as a general rule of thumb, something that's quite useful and protective as a measure would be to try and get multiple fee estimates. I think that's helpful. So if you can get, say, 3 estimates, for argument's sake, when you're looking at which expert to instruct, then it gives you something at the end where you can start to say to the judge, look, we considered what would be reasonable and proportionate on this case. We've got 3 sets of fees from 3 different experts. That varies from X to Y. We chose the one in the middle. We think that's reasonable and proportionate because we haven't gone for the most expensive one. But this is the reason why we went for the middle one, because we've got more experience. Maybe they were able to turn the report around faster, which was needed for the court timetable. So you can start to think about these things, but I think it's about having cost kind of almost at the forefront of your mind when you're running a case. Whereas in the old days, it was very much you get to the end, you deal with that at the end. But it's still tricky because you can do that exercise, as I said in the Santiago versus MIB case with the interpreter fee, where you can do all that exercise, get the comparable evidence, and the judge can still say, I still think that looks a bit too high. So,
were you arguing for judge shopping or transparency there? I couldn't make up my mind.
Well, you can't do judge shopping, unfortunately. So I would argue for transparency.